The Indian River County Planning and Zoning Commission meeting of April the 22nd, 2010 will come to order. Please stand for pledge. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Need an approval of minutes for March 11th, 2010.
So moved.
Second.
Moved and seconded. All in favor?
Aye.
Thank you. Item number 3 is a public discussion, Waterway Village, Plaza Judicial. Would anyone who plans to speak please stand, be sworn in.
You raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Mr. Keating.
Yes, John.
John, okay.
Thank you, Chairman Smith. John McCoy with the Planning Department. I'll be presenting the Waterway Village Notice of Proposed Change. And this is an application from Pulte Homes to modify the Waterway Village Development of Regional Impact. And the purpose of the application is to settle a lawsuit between Pulte Homes and the county. That lawsuit's been running now for a little over 3 years. And usually from current development, you see design changes and you see graphics. In this particular instance, we don't really have any graphics for you. It's all text changes, and those are changes to the development order and changes to the developer's agreement that are related to the development of regional impact. So there's no new units, no design changes. When you're changing the development of regional impact, essentially they can fall into two categories. They can fall into what's called the minor amendment category, which is where this one falls. And with the minor amendment, the impacts are essentially local impacts. And local means within the county. In the other category, it's a substantial deviation. Those impacts are far-reaching, and they are essentially regional impacts that would go beyond the county. This Notice of Proposed Change has been reviewed by the Regional Planning Council staff, and they've indicated that they believe that the issues are indeed local issues. The next slide I'd like to go over is just the actual location of Waterway Village. I believe most of you are familiar with it. It is located in the central county between 49th Street, essentially just south of 53rd, between 58th and the lateral H Canal on the east perimeter. Most of the development to date has occurred on the west perimeter, and that's approximately 300 units have been built on the west perimeter. The next slide shows the physical characteristics of the site, shows where most of the development has occurred, and shows two features that we're going to talk about in a little bit greater detail. And that's 53rd Street from 58th Avenue to the east project boundary, which is the developer's responsibility to construct. And from the aerial, you can see that essentially it looks in, and a portion of it is paved. The rest of it is fairly far along, and probably about 50%. They've got it roughed in. They've got a lot of the underground stuff done, but all of the surface work still needs to be done. The other physical feature that we're going to talk about a little bit later is 58th Avenue improvement, and that's a new improvement that's not covered in the existing development order or developer's agreement, and that's a project from the 53rd Street intersection of 58th Avenue down to 49th Street. With that, I would like to go into a little bit more detail on the 53rd Street construction aspect. And as it is right now, the developer is responsible to construct that segment along their entire perimeter from 58th Avenue all the way to their east property line. They're required to construct it as a 4-lane segment. As the condition is today, they're required to construct it when they hit the 1,000 building permit benchmark. Like I said, they're at about 300 now, so that time frame is about 5 to 8 years in the future. The proposed modification to the developer's agreement would advance that, so it would most likely be in the next 2 years as far as their construction responsibility. The development agreement also provides for the developer to donate 100,000 cubic yards of fill for the construction, so it facilitates it in that respect as well in the physical sense. The county sees advancing this construction as a big benefit, a large benefit, and the concept of the condition is the county would be responsible for the construction of 53rd Street from US 1 west to the developer's project. The developer would be responsible from 58th Avenue east to their east property line. Once the county kicked off construction, commenced construction, we would notify the developer. They would build their portion. The two segments would be done essentially simultaneously, and the segment would be complete so that 53rd Street would be constructed between 58th Avenue all the way to US 1. And that's the essence of the condition as it's modified. The next item I'd like to talk about is concurrency vesting. And the concurrency vesting is the main issue that initiated the lawsuit in the beginning. And it's the developer's position that they are vested for concurrency by virtue of having an approved development of regional impact, having an approved development order, and having an approved developer's agreement. So they believe that they're vested for concurrency. Based on an opinion from an outside counsel, it's that the county's adopted, it is the county's position that they're not vested for those and that they have to undergo concurrency tests at each point in the process. That's the item that's been in negotiations these last 3 years. And we've essentially all agreed to settle by agreeing to vest the project units in an incremental basis, essentially in sort of 7-year rolling windows. So as far as the settlement goes, we're about 98% of the way there. There's one item that we disagree on from the planning staff to the developer, and that's investing. The developer wants to essentially unbundle the concurrency categories, invest only for traffic, paying the traffic impact fee only in 2015. And it's the county staff's position, and it's consistent with the land development regulations, that they need to vest for all the concurrency categories in 2015 and pay all of the impact fees. And again, that's consistent with the county code. The attorney's office has indicated that the board does have the ability to unbundle them, but there are some things that need to be done if they choose to go that route, and they need to, the county attorney's office probably needs to give more input if that's the path that's chosen. It's the staff's position, the staff is recommending the condition that at the time of impact fee payment, that includes all impact fees. The next item I'd like to talk about is the new improvement, which is construction of the 58th Avenue improvements. And it's a new improvement that's needed to vest concurrency for the entire project. And the improvement consists of widening 58th Avenue from 2 lanes to 4 lanes from 53rd Street to 49th Street. And it sets out the timing for that. And essentially it's a 2-pronged test. One is a monitoring condition, and the other is a time certain. Whichever one they trip first, that's when the construction would commence. A couple of other items I'd like to touch on. The intersection improvements to 58th and 49th are already covered in the developer's agreement and the development order, but this would change the timing of that, and it would change it to the timing when 58th Avenue work is done, so we don't tear up 58th Avenue and 49th Street intersection twice within a period of 5 years. We're going to group those two improvements together and have them done simultaneously. The other is 58th Avenue and 45th Street, and that's essentially tied to a building permit threshold, but the county has not acquired the right-of-way for that, so it changes the timing of that to correspond with when the county does acquire the right-of-way for that particular improvement. And then the last one I want to explain in a little greater detail is extending the build-out date from 2012 to 2024. Essentially, within a minor amendment, you can extend it 7 years before there starts to be any questions. In this particular instance, the build-out date was 2012. Last year, the legislature granted a 3-year statewide extension to all DRIs, so that takes it from 2012 to 2015. The statute on DRIs essentially says the clock stops, the time tolls when there's a lawsuit going on. So that's 3 additional years, gets you to 2018. The 7-year minor amendment would get you to into 2025, and the applicant's asking to go to the end of 2024. With that, I would like to get to staff's recommendation. Staff does recommend that the Planning and Zoning Commission recommend that the board determine this application does not constitute a substantial deviation. It adopts the resolution as amended and approves the revised developers agreement with the condition as recommended by staff about the timing of the impact or the payment of the impact fees. Thank you. That concludes our presentation.
John, so the problem is the payment, the timing on the impact fees.
It's not the timing, but it's
What's the dollar split? I mean, one is traffic impact fees and one is all. So what are we talking about?
there's not an exact figure, but it's well into the 7 figures. It's could be somewhere between 6 and 8 million, I think.
Difference. Okay.
The applicant may tell you better. They may have researched it further than I have, but that was just a thumbnail.
John, this is unique to Indian River County, is it not? Because this is the DRI that we are involved in currently, and would have no effect on any other development that's occurring in the county?
As far as potentially the settlement, I believe the settlement is unique. In other words, that it would make a distinction and qualify it separate and apart from other developments, yes.
Is it setting precedent for any future DRIs that might come in?
We have talked about that, and at the front end of any DRI in the future, we would make a point to have a condition that resolves the concurrency issue.
What is the time frame? If you accepted the smaller number, what would trigger the rest of the impact fees? What's the time frame? Is it as it went in, or what's the time frame you're looking at? The furthest time frame out would be at unit construction. Is essentially the furthest go
time.
out through 2015, 18. So okay.
As the units were constructed.
Is it possible that there wouldn't be concurrency available for the things they don't want to pay for at the time that they break ground for them?
I think they always run that risk, and that's again the risk that the developer would be accepting if their method was approved.
Wow.
Money's tight. Sounds like it.
Council, could you comment on the yay or nay vote by P&Z? What's the effect of either?
Tonight, this is just a recommendation to the board whether to accept the settlement. Staff's presented one argument. I think the applicant's going to offer a different argument, and you're going to weigh the merits of the arguments and decide whether it should be recommended or not to the board.
But basically, the applicant has accepted all of these other items in time, with the exception of the money issue on the payment of the impact.
Correct. Like I said, I think we're 99% of the way there. It's just that one small item. And again,
being as Alan is here, and we've all believed in splitting the baby in the time of Solomon. Is this either one way or the other way? There's no in between, middle of the road here.
Well, you're talking about essentially prepaying the traffic impact fees. Keep in mind,
They've agreed to do, right?
yeah, keep in mind the way this is working is actually they're paying all impact fees as they go from now until December 31, 2015.
On what is in.
Yeah, as they pull the building
Right,
permits.
okay.
So all the payment of fees up until that time is normal.
Right.
At that time, under normal circumstances, they would not pay any fees until they continue to pull building permits going forward. What they're actually doing is prepaying the traffic impact fee portion of that. So all the units for which they have not pulled building permits up until that time, they're going to prepay those fees on December 31, 2015. Thereafter, they're going to pay the rest of the
When they
impact
pull the
fees.
permits. And, as they pull the permits.
Yeah, the rest of the impact fees will be paid as they pull permits going forward.
So if they stayed on course right now, just under normal circumstances, they would be paying impact fees as they pull permits, right up front, by the end of this year, we're ahead of the game by receiving all of our traffic impact fees in the beginning.
Well, in December 31, 2015 is when you will receive all of those traffic impact fees.
For all 1,500 units?
For all of the 1,596 units for which you have not received traffic impact fees up until that date.
12/31 when?
So what you're actually getting an advancement in the payment of the fees compared to what they would be.
But it also is a way to cleverly resolve the question of whether they have vested concurrency for that or not. And this is, they're saying, we'll pay you in advance to make sure that you assure us that you're going to set aside.
Right.
That is the nature of this agreement. And I guess getting back to the question I originally had, don't they still run the risk with the other issues upon which they have to have concurrency we're back to square one in terms of the lawsuit if there's determination by any one of the other impact fee categories that there is not concurrency there for them to carry on with their construction.
I made a recommendation to staff earlier today that if the P&Z decides to go with their interpretation and allow the payment of only traffic impact fees in 2015, then I think the document should be clarified to say, therefore, are not vested on the other concurrencies, and they will be tested as they pull the building permits going forward. Right. And it is a risk that they run, and I think they're well aware of that.
Bob, how do you view this in relation to other developments out there that were coming online at the same time and created this problem with traffic concurrency? For example, Antilles. I mean, are some of these other developments just going to be closed out of luck?
Well, first of all, the difference here is Waterway Village would be getting vesting without paying all of its impact fees, which is different from the way we treat everyone else.
But Bob, we just heard that's only on traffic, which they'll pay for, but they are not vested on anything else.
No, but what concurrency means, you're good to go, you can build. It doesn't mean that capacity is reserved for a specific facility type. Bottom line is, if you have concurrency for your project or part of a project, that means you're good to go. There's capacity there for everything. We have never unbundled in the past, and that's not the way.
So your concern is that even though they pay the traffic impact fees, in your mind you're saying once they've done that, they've got concurrency, and when they come back you're going to have to give them the rest of the impact, or water, whatever, sewer, and when they pay for it, even if we didn't have it.
No.
No, what I'm saying is that no other development can do this. A lot of developers would love to do this.
What got us into the mess, as I remember, is that they came up with a DRI from the state level, which they believed overrode our local rules. We argued against that, and that's why which is completely different than anything else we have here at this time.
Right, and this is a settlement to resolve those, and the one outstanding issue that there's been back and forth on is the timing of the payment of the impact fees.
Okay. Yeah, I'm inclined to like it, but I think the main issue, we're just punting into the future, which is whether or not is the very nature of the lawsuit, whether or not the DRI overrides the local regulations, and all we're carving out is just traffic. There's all the other ones that are still going to exist, and it doesn't seem like it's a settlement at all. It seems like it's delaying the ultimate issue for a future time. That's the way it seems to me now. I mean, I'd like to hear more about it, but that doesn't sound like much of a settlement.
Okay. Bruce, do you want to comment specifically to Sam's? Okay.
Yes, please.
Hello, that.
Bruce Barquette, representing the applicant. Commissioner Zimmerman, you raised the correct issue, and that's our part of the compromise. We have agreed to waive concurrency for those other components other than traffic after 2015. That's what makes it a compromise. We have, and I don't have any objection to Alan's proposal to add language, because right now to add language it says, by entering into this agreement, we acknowledge that concurrency may not be available for recreation, schools, utilities, whatever. We're willing to do that.
It's a risk we're willing to bear.
It's a risk we're willing to bear because we can monitor that. But that's what makes it a compromise. Otherwise, we sit firm. Otherwise, I'm very confident in my case that we win in court because I drafted the documents. And I think we're vested to the end, and there's nothing you can do about it if and we don't have to build 53rd Street right now, and we never have to build 58th Avenue because it's not in our developers agreement. So we reached this compromise. We advanced 53rd Street to now, instead of John's optimistic approach was 5 to 8 years, but at current rate of growth, it's more like 7 to 10 years. And we take on the new obligation to widen 58th from 49th Street to 53rd Street, which is not in our DRI, and which our developers agreement specifically says we don't have to do.
And you're prepared to live with the substantial risk looking into the future.
Yeah, it's only a substantial risk to you. We are very comfortable that there's not going to be capacity issues on those other projects, on those other components. But it is a risk.
That's got to be the case, is that they must feel like it's there, or they're monitoring it, and I suppose if it comes up, then they'll pay it at that point.
Correct.
I mean, they'll jump
That's
in
exactly what we can monitor it. So, but you're right. I mean, it would be a risk, but for the fact that we acknowledge we're waiving that, that's what makes it a compromise on our side. I don't know if I'm making that clear, but...
No, I understand.
Yeah. Okay.
Bob, I'm not sure I understand. I mean, I understand the money issue, I guess. I mean, the county, it's more money for us in the county, but I'm not sure why you all would think that this is, I mean, it does sound like an awfully, a fair compromise to a point. And I don't see what the risk the county has, except that we don't get the $5, $6, $7, whatever $1 million up front, but we're going to get it over time when they pull these permits.
Sure, but we don't allow that of others. And with the county's compromised significantly. We're reserving capacity from right now to the year 2024. So that means for capacity, I mean, if you accept their premise, it's capacity for traffic. So those trips are going to be on the road for 14 years, where someone else coming in can only reserve for 3, unless he's doing a major project, and then he can go to 7.
Wasn't that the whole premise of this lawsuit with the DRI? I mean, how far do we in the county want to take the chance that
right, and that's how
Bruce may be right, he wins,
and that's our settlement. That is our settlement, is giving concurrency longer than is allowed right now for regular developments that come in.
Alan, let me ask a question. The language you have in mind, is that going to stipulate that they accept the fact that the local rules govern the additional concurrency things, and they're going to waive their argument that the DRI overrides all of the other things? Is that the language you have in mind?
Well,
so that we're not back to the lawsuit over the DRI.
If this doesn't happen, they say, well, the DRI overrode you anyway, we get it back.
Yeah.
No, by reason of this agreement, they would clearly be acknowledging that as to those other concurrencies,
local rules rule.
Yeah, they are waiving any argument that the state statutes override any local rules and therefore vest them. That is part of the compromise that they're giving up.
Big deal. I mean, I sympathize where Bob and them are. I understand the principle that he's talking about, but this is a bigger project, and I have to. That's why I was asking about splitting the baby. I mean, can we throw in a couple other impact fees on the side and then let the rest ride or something? I mean, but that's.
Bob, let's go back just a step. You're concerned about other projects, but we have no other DRIs, and in this economic condition, the opportunity for that is probably not great in the near future. So what is your concern about other local projects?
Well, and actually, for future DRIs, we'll address this issue up front. And we'll make sure that we...
I was going to say, the precedent that's actually being set is good for the county, which is that the local rules override the DRI argument, steamrolling the county.
Right. If there's a DRI in the future, we're going to address all these issues up front, and the development order will be clear as to how long vesting is for, when impact fees need to be paid, and things like that. I think the point that I'm making is we've applied concurrency, vesting, and payment of impact fees consistently through the years. As a matter of fact, we were sued several times when we wouldn't let people pay all of their impact fees and reserve capacity.
In smaller projects.
Yeah.
Not DRIs.
Yeah.
But I mean, so your heartburn is really the fact that we've done 3 or 4 years and they're going to get to roll out for 14 and say la vie. Because they're going to write the big check and they get it, and that's the way life is.
Right.
But it's the settlement of a lawsuit.
That's right.
And I will add, one of my concerns going in was the question that's been raised by a couple of you: are we setting a precedent that's going to burn us in the future? And I think the answer to that is no, because, number one, you are dealing with the DRI, which brings in different laws than all of the other developments. It's because of those different laws that they are taking their position that they are 100% vested and that we have this lawsuit. So those different laws, which have been kind of the genesis of this whole issue, don't apply to anybody else. And as we go in the future, should we have other DRIs, as Bob is saying, we now have a spotlight on this issue so we can deal with it by the order and the agreement up front. So I think you're okay in terms of you're not going to be setting a precedent that will come back and hurt you.
The reality is, Bob, is it's the 3 or 4 years that's bothering you, but the real reality is, as you said, you wouldn't be bothered if they paid it all up front, which is exactly the same thing that should be bothering you on all the concurrencies, except that you got it done, you got all the money, and you're up front.
No, we recognize that we have to compromise in the lawsuit, and we have compromised. It's just the additional compromise that we're talking about, the money part.
I understand.
In a very global sense, they are contending in the lawsuit that they are fully vested for everything. We are contending in the lawsuit that they're not vested for anything. And essentially, under this compromise, we're coming into the middle and saying, okay, you're vested as to this, you're not vested as to that, and you'll prepay some fees. So, in a global sense, it's kind of meeting someplace in the middle of this disputed issue.
Well, I think as long as there's language that in very clear terms stipulates that they are foregoing the argument in terms of future vesting of concurrency, that the DRI overrides, and they understand that, they're running some kind of risk. I can't, say how much it is. That's for them to determine. That in the future there may not be concurrency for them to move forward with their development in any of these other categories. I mean, I think as long as that's clearly stipulated, then that is the compromise that their attorney was talking about. I mean, that's a legitimate risk. I mean, as long as it's documented properly, which it's currently not, correct?
Yeah, currently it is not, because staff has been urging the opposite position.
Correct.
But if you agree with the developer's position, then it needs to be documented.
I mean,
it would be.
It would beg to ask is how do we feel if in 2017 they realize concurrency is evaporating and they want to write the check for everything? Are we going to let them do it, or are we going to make them do pulling permits one at a time and paying concurrency as they go? Or can they get in on a lump sum in the future on the balance of concurrency, or are we going to stipulate that they can only do concurrency based on pulling permits from there on?
I think they could be just like any other 3-year initial concurrency applicant and come in and they can do it at building permit time, or they could get a 3-year vesting for the other facilities at some point in time and pay the balance of the fees.
Understand what they're talking about, because I think we're talking. It sounded like to me they were talking about the possibility of vesting everything if they needed to. That's one of the reasons they're willing to run the risk.
There's nothing in the settlement agreement currently that would allow them to prepay the other fees or somehow, receive special treatment with respect
once
to
this
those.
is done, so you limit to 3 years. Okay.
Bruce, I'll let you go again. Other than that, I want to get Commission's questions of staff, and then we'll give you appropriate.
I understand. I think under the agreement we could do it in 150-unit increments, rolling for every 7 years. I think that's what the nature of that 150 units every year.
So you accept the fact that it's not 100. You can't jump out into whatever year it is and say, okay, whoa, man, this is bad. We're going to buy it all. We're going to pay all the concurrency up front. You still have to do it in incremental leaps and bounds.
Well, right now the way it's written, I think we can only do it 150 unit
okay,
increments.
but you're comfortable. You're comfortable with that, because in these other concurrency issues, you don't think you really see a risk anyway.
No, I don't think I see a risk. I mean, to be honest with you, sir, what you're asking me is something that the details are what become difficult to write. So in concept, I don't disagree with you, but I can't commit to that until I see what we're trying to write.
Right.
Because if Sam writes it, I'm kind of afraid of it at this point.
Bob, is there a risk, or is it? I mean,
sure.
There is some risk.
Water, sewer, and schools.
It's legitimate.
Yeah.
Okay.
Yeah.
Thank you.
Special water. I have a question to staff. On the 7-year vesting, are they going to be limited to 7 years? If they're in 2023 and we're past our 7 years, what happens to that vesting that they've already paid for on the traffic concurrency?
Well, right now the build-out date in the DRI is 2024. To go beyond that, they would have to go through another amendment of the DRI.
Okay, so if they vest right now for traffic concurrency, they're vested permanently, we're not talking a 7-year issue then?
I guess what happens after 2024?
Well, actually, it's 2010 now. If they go to 2015, what happens in 2022,
What
2023?
the way the settlement is structured and the way the development order is structured is, as John indicated, he talked about 7-year rolling vesting. And the vesting is starting in certain years, like in 2014, there'll be 150 units vested for 7 years, so that to 2021. In 2015, another 150 till 2022. So we are not violating our 7-year vesting limitation.
But let me answer a little further. Once that window closes, that 7-year rolling window, I think that's your question, is once you get outside the far end of that 7-year window, they become essentially like any other project. They lose that vesting.
Okay.
If there's capacity there, they would come back, get back in line. Their fees would still be there, and they would run with the land, but they would have to make sure that concurrency was available for that particular unit that the window closed on.
I'd like to see that wording in the agreement too, because I'm not sure if there's a thought process that says, well, no, we're vested for eternity, or there's not a thought process, but I'd like to see that actually in the wording so that it's very clear that they are restricted to the 7-year. It is? I mean, if you have a new agreement, Bruce.
Commissioners, other questions of staff?
This is a side issue. It's a small issue. The widening of 58th, what's the thought there? I mean, in 58th, there's going to be 2-lane north of 53rd, and it's going to be 2-lane south of 49th, right?
Correct. And our traffic engineering folks are here, and they can add more detail to this, but the thought is in the immediate vicinity of Waterway Village, you're going to have 53rd Street as a 4-lane segment going east and west, being essentially the main artery or funnel east and west, so that additional 4-lane capacity will benefit you right in that immediate vicinity. You're correct, as you go further north, there's a bridge that would need to be widened, and the most logical progression would be to expand south toward State Road 60 to pick up additional capacity in the future, but the idea is 53rd Street.
The county has no plans for a road widening project on 58th in the next 5-year capital improvement plan.
Correct. Right now, the right-of-way is there because Waterway Village has provided the right-of-way for the widening of that segment. And again, the thought is that with 53rd Street being that big east-west corridor, that it provides some additional benefit and capacity for.
How about we let them go build a bridge at 66th and pave 66 on across anyway, forget this 58. Let's do some good.
I think it might affect their concurrency.
It seems like to me that if they're going to widen 58 from 53rd to 49th, and the reason you're doing it is to handle traffic, that then necking that back down going south to the 2 lanes from the 4 lanes is going to create a traffic problem. I mean, it just seems like you're going to be putting a bottleneck in there.
It seems like we're just smacking them.
Yeah, right. Yeah, right.
Slap, like here's something else you can do.
Yeah,
it doesn't make sense to me to do
throwing them on the table.
Cause more trouble.
I have one question about the road improvements. It seems like we're tying Devasta into a nice little corner, but this improvements to 45th Street and 58th Avenue is being tied to the county acquisition of the necessary right-of-way to construct the improvements. So now the county's going to have to come to the plate on this. What's your timing? I mean, how are we going to get our timing down in a certain time frame?
I don't have the details on that. I believe we're under negotiations with the property owner to actually get the property for that improvement. And I believe some of our public works staff is here that may have more details.
Are we using the expedited right-of-way, the legal thing that we were supposed to have adopted but really didn't but may have?
Chris Moore, Public Works Director. What we're doing is 58th Avenue is not actually part of the county's 5-year plan of improvements currently, but as part of this improvement that Devasta has to do, we're assisting in a way that we can, and that is acquisition of right-of-way. We have eminent domain powers, a developer does not. So they came to us and asked us to assist with the right-of-way. We can do that, and we are doing that. But because we've got resistant property owners along 45th Street, it's taken a little more time than we thought it would, and we're working with Devasta on the design of the intersection to take the corridor along there that would acquire the least amount of right-of-way and would have the least impact on property owners. So we are assisting them with it. It's taken a little bit of time, but we can work in the time frame that we've got spelled out in the agreement.
Which would the county rather have, 58 4-lane or your impact fees paid up front?
Well, we'll end up getting both as part of this agreement, depending on, what time frame you're talking about. They have to do the 58th Avenue intersection at 45th Street, and then at some point, they also have to do the 4-laning of 58th.
Early or late, yeah.
Right.
Are we doing anything with a little forethought on 58th as to, instead of creating that bottleneck, do we have a plan to, fix this before it becomes a problem?
Well, the idea of a bottleneck really isn't going to happen. I mean, the way that the trip distribution and the modeling that Devasta did showed that their greatest impact was on the closest link of 58th Avenue to them, which was 49th Street to 65th Street. Now, ideally, we'd like to get that whole link 4-lane, but by 4-laning just a half mile of it, they raised the capacity of the entire 2-mile link by 25% of a 4-lane improvement. So they agreed to do that. They modeled it, and it just so happened that that link is, since it's the closest to their development, is more highly impacted than all of the other links along 58th. Now, a lot of their traffic will end up going, I think they had a model run that showed that 25% of the traffic is going to end up going east on 53rd Street once that is improved and connected to Old Dixie and ultimately to Indian River Boulevard. So it disperses, but the portion of 58th that's closest to their development gets the heaviest impact from their development, and that's 49th to 65th.
So the answer is no, we don't have any plans to.
Well, we don't have a plan to widen, to 4-lane the rest of 58th. It's not in our 5-year plan currently.
Okay, that was my question. Have we given it any kind of a priority that maybe getting it back into the 5-year plan?
If in future years it gets to be a problem with concurrency and capacity, yeah, sure, we'll petition the board to add it back in, but right now it doesn't show that.
Thanks, Chris.
Other questions of staff? Thank you.
Not on this issue, but in reading through this, and I think it's got to be a mistake on page 12, number 35. Isn't that supposed to be protect instead of protest the bald eagle's nest?
Yes, that would be true.
Depends on what side you're on.
Yeah.
Is he still there?
Yes.
Or she?
Okay.
Got that? Mr. Barquette? You wish to speak?
Actually, I pride myself on not speaking unless I have to. So unless you have any questions, I think we're here to answer them. But other than that,
Bruce, depending on the outcome, you're in agreement with everything about the rolling numbers. You pay your traffic fees up front. You 150 units. You roll the role of the concurrency from there on, and the subservience, I guess, to the local county versus the state. I mean, you get what in your settlement. Is that what we understand?
yes, sir. And I think what y'all need to understand is that concept has already been before the county commission. They approved it back in July, and I wasn't part of that negotiation. My co-counsel, Mr. Smith, was, but the short answer is yes. We are in agreement.
Right. That's all.
Thank you. All right. Thank you.
Thank you. Any member of the public who wishes to speak? You have to be sworn in. Seeing none? would entertain a motion.
I would, I'd make a motion that we accept the Waterways proposal as best we can, that it doesn't sound that bad to me, and with all of the stipulations, like what Donna said, the details about the rollout, that we're clear about the lack of vesting in the future, and I would so move.
Second?
Any discussion?
Yeah, I have a question.
We have a second?
Yeah, second for discussion.
I wasn't seconding. I was asking for a second.
I thought you seconded.
Yeah, I thought you'd seconded too, Greg.
I'm sorry, I didn't.
Really?
Not really allowed.
Question mark at the end
No,
of that
I
second.
can't.
So, George, your motion includes staff recommendation that the request does not constitute a substantial deviation and all the rest of that stuff.
Right, right.
Okay.
But they don't get the money till they pull the permits.
You're not addressing the bundling versus unbundling.
Oh, yes.
Well, in a way, he is, because he's saying that with the addition of the stipulations that we talked about, wherein they acknowledge that the local rule takes precedent over the DRI, and that they are substantial risk for not having concurrency on the additional issues.
He is unbundling.
Right.
He isn't. You are.
I am unbundling it, yes.
Yeah.
I'm unbundling it, which makes them local to county rule versus state rule, in my opinion.
For everything but traffic.
But everything but traffic, because they're going to prepay. Well, actually, even in traffic, they're just simply prepaying the vesting in traffic ahead of time.
But they're still unbundling, though. That's what they're seeking permission. That's different than what staff is asking, is that they're, instead of paying them all up front, they're just going to pay traffic, which is contrary to staff's position.
Commissioners, wait a minute.
Right. Yeah, I think we.
George, you need to restate your motion, please.
What I
And want a
understood
second.
is that with, what I understood was that everything, and the bundling part, I wasn't really dealing with. I was just simply dealing with the fact that it looked like they were 98% in agreement between what they were doing on both sides. And the one issue that seemed to be the hang-up is the payment of the vesting on traffic versus all concurrency. And I am in agreement with Waterway Village that they can pay just the traffic, and they'll do, but into the future, they live with the county rules. They live with the risk of not having concurrency available in the future. They have a rollout that's in place already on the units as they go ahead. And that they simply, I'm saying I understand where the staff is coming from on the payment of vesting, but I think that it's a good agreement without squeezing that hard. I think we ought to accept what we've got. And that's what
I agree with you in principle.
Okay.
So
I mean, that's what if there's more to it than that, then I would be happy to listen under discussion. That's what my motion.
Thank you.
Okay.
Do I have a second?
Second.
Thank you. Discussion.
I would only say this. I think it settles a couple of good things. It settles the lawsuit. It coordinates with our Public Works timetable, which is meaningful. It accelerates revenue to the county, which I think is not a bad thing. It's not a good enough reason to make the decision on its own, but it's not a bad thing. And if we add the stipulation, I think it's a fair compromise to the unresolved issue. I think the language needs to be pretty tough and only interpretable one way. But if we can do that, I think it's a fair compromise to the unresolved issue. That's my thought.
Is there anything else you would like to say in the wording of the motion that we did not cover?
No.
Okay.
I have a question of counsel, and that is whether or not the status of this project as a DRI and the status of this situation being a settlement for a lawsuit is sufficient firewall to, in your estimation, to prevent other potential applicants from wanting to be treated in the same way with respect to concurrency.
Oh, you mean as a precedent? I think that's fair.
Well, I can't tell you that somebody else won't want to be treated, which was your question.
Yeah.
But I think that there is a sufficient firewall, given given the DRI status, the different laws that apply to DRIs that don't apply to other developments, given the fact we're settling a lawsuit. So I think there is a sufficient firewall.
So we'll have a strong enough argument. You feel that way as well, Bob? That we won't have to offer the same kind of unbundling, the same kind of potential extensions to anybody walking in the door.
If that's what you meant by bundling, I clearly intended this is just this case.
Yeah.
So staff's real objection is just that it's not consistent with what we've done in the past. There doesn't seem to be a threat that it's going to come up again and again and again.
No, it isn't that. And the reason our regulations are structured the way they are is that that capacity being reserved is a precious commodity. It has a value. And the whole idea is you should pay for something when you're consuming it, and it is consumed when we have to reserve it. And concurrency is not just reserving capacity for this or this or this. Concurrency is a statement that, yes, the unit or the project or the part of the project is buildable. All of the facility issues have been resolved, and there's adequate capacity there. It's not the part of the capacities there. It's all or nothing, the way our regulations are.
I feel that DeVosta, once they start getting close to the capacity issue and any of these things, they're going to ante up.
I do too.
So I understand your position. I really would like to just call the question.
Other comments? Hearing none, all those in favor?
Aye.
Aye. Those opposed? Thank you.
Come on down. Thanks, Al.
Thank you. All right. Stan, who has the public hearing?
I believe Mr. Keating is taking the first item.
Okay. Item 4A.
Good evening. This is the first of two comprehensive plan amendments that you're going to hear tonight. And I just want to give you a brief overview of the comprehensive plan amendment process. As you know, the county, like all local governments in the state, has a comprehensive plan. The comprehensive plan was approved by the state, and the state has set certain parameters, certain requirements regarding amendments of comprehensive plans. According to state law, a local government can amend its comprehensive plan only twice a year. And the way the county does it is we accept comprehensive plan amendment applications in two windows during the year, January and July. In this case, the amendments that we're considering tonight were submitted during the January amendment window. And this is a long, involved process. Generally, it takes 8 to 10 months. It involves a public hearing tonight before the Planning and Zoning Commission where you make a recommendation to the Board of County Commissioners. They have a transmittal public hearing. If the board opts to transmit the amendments to Department of Community Affairs, Department of Community Affairs and other state and regional agencies review the amendment, provide comments, recommendations, and objections to the county. County addresses those, and finally, the Board of County Commissioners will have an adoption hearing. Like I said, maybe 5 or 6 months from now, making the whole process 8 to 10 months overall. That's kind of an overview of the process that we're going through. As I said, tonight we've got two amendments. This first amendment is a text amendment to the comprehensive plan, and involves changing policies 1.22 and 1.36 of the future land use element. Now, as I said, this is a text amendment. Most of the time you see land use map amendments. A text amendment actually changes the wording in one or more of the policies of the comprehensive plan. In this case, the amendment involves modifying two of the policies in the future land use element. And actually, this first amendment, this text amendment, is related to the associated land use map amendment that you'll hear next. As a matter of fact, the map amendment that you'll hear next is dependent on policy 1.22 being approved. And policy 1.36 that you're looking at changing really will modify the land use map amendment. And we'll get into these a little more as we go on. But basically, the approval process for this text amendment is the same as the approval process for the map amendment. What I'd like to do is address both of these policies that are proposed for changing tonight, address them separately. First, policy 1.22, let me give you a little background on this. This policy was adopted when our current comprehensive plan was adopted back in 1990, and policy 1.22 prohibits expansion of a commercial industrial node unless the node's at least 70% developed, and there are a few exemptions to that. But basically what this policy does is it establishes a need-based standard for node expansion. The premise is that if a node isn't at least 70% developed, then there's not a need to expand it. So I think this policy really makes a lot of sense. And this policy applies countywide. So with respect to this policy, we're not looking at any particular piece of land in the county. We're looking at just generally, is this an appropriate policy to have countywide that would apply everywhere? As I said, there are a few exemptions to policy 1.22, and you've seen these a number of times as we've brought map amendments to you. And basically, the context of the exemptions is that some circumstances actually warrant expansion of a node even if the node isn't 70% developed. And a couple of examples of that, actually the last set of comp plan amendments you saw involved a swap of land use designation. So that's one exemption where you can actually expand a node because you're contracting another node and there's no net increase in node acreage. Another exemption that we have is accommodation of a use with a substantial land area requirement and no available alternative sites. Currently, that exemption references regional malls, and that makes sense. And that's the part of the policy we're proposing to modify tonight, adding large-scale industrial parks to it. Another exemption is a node can be expanded even if it's not 70% developed, if it's compensation for right-of-way taking. And there are several other exemptions that we have, but that just kind of puts it in context how policy 1.22 works. As far as the specific wording change to 1.22, that's in your backup, but just paraphrasing it, the proposed change is to designate large-scale industrial parks as a use which has a substantial land area requirement and warrants node expansion when no alternative suitable sites are available in existing nodes. That's the basis of the change that's proposed tonight. And going forward, what we need to do is provide justification as to why this policy needs to be changed. And the justification really relates to the need for large-scale industrial parks or a large-scale industrial park. And there are a number of reasons that we do need a large-scale industrial park. One is the evaluation and appraisal report that was adopted about a year and a half ago. The findings in the EAR said that right now the county doesn't have sites for large-scale industrial users, and that's one of the reasons that it would be appropriate to have a large-scale industrial park. And the draft EAR, and I guess I spelled ear wrong here. I seldom spelled three-letter words wrong, but the draft EAR-based amendments that we just went over on Monday, the economic development element actually has a policy for the county to have 2 new business or commercial industrial business or industrial parks in the future. Another reason why this proposed change is justified and why there's a need for large-scale industrial parks is even since the evaluation and appraisal report was adopted, the Board of County Commissioners has been a lot more proactive in economic development. The board more than doubled the jobs grant amount that we provide to businesses and industries coming in that qualify for it. The board has scheduled a referendum on a tax abatement program that the county is looking at having. The county has made some impact fee changes, suspending 5 impact fees for a year. And the county until recently was looking at designated a designating a brownfield site. All of these are activities that the board has undertaken with the expectation that we're going to have more economic development and that there will be more of a demand for industrial sites and a large-scale industrial park. And another reason is we've got 2 partially built parks out there that the county has depended on to have actually shovel-ready sites in place, and they're not going anywhere. One of them is in foreclosure, and we don't know when that's going to become a viable park, and the other one doesn't seem to have moved along recently. So that's a 4th reason. And the last reason is right now, if we don't act, we're going to lose some land that is really some of the only land that we can expand the best commercial industrial node that we have out there for industrial uses, and that's the State Road 60 commercial industrial node. And the land that we would lose for expansion we'll be discussing a little more tonight, but it's part of the Corrigan property that is part of this amendment, and if it's not included in this, it would be included in a wetland mitigation bank that the Corrigans are proposing and would not be available for node expansion industrial development in the future. Just going on with some of the justifications of why we need a large-scale industrial park and why this proposed change is appropriate is, first of all, I don't think there's any questions that industrial parks have substantial area requirements, and they're similar to regional malls in that respect. And staff has checked and looked at our commercial industrial nodes, and they're just there aren't any nodes in the county now that could accommodate a large-scale industrial park. Now, even though there are a number of nodes that are less than 70% developed, there are several reasons why they can't accommodate a large-scale industrial park. First of all, in the nodes that aren't 70% developed, there's that undeveloped property, those undeveloped sites are generally scattered and they're smaller, and they really can't be assembled into large tracts that would accommodate a large-scale industrial park. Another reason is our commercial industrial nodes accommodate both commercial uses and industrial uses, and most parts of most nodes are appropriate for commercial uses, not industrial uses. So that's more justification. So for those reasons, staff feels that it's appropriate to designate large-scale industrial parks as a use that warrants node expansion, even if 70% of the node isn't developed. Now that's policy 1.22. Yes.
Before you go on, with the business incentives and the suspension of the impact fees, that's really not going to apply with this. I mean, if it's only for a year, we're not going to be looking at that suspension applying to this, because this is going to be further down the road unless they continue it.
And that's correct. I was just pointing out that the board is taking some affirmative action in the economic development sphere. With policy 1.36, again, let me give you a little background on this policy. This policy was put in the comp plan in the mid-1990s, and it was put in at the same time that 101 acres of property at State Road 60 and 98th Avenue, north of State Road 60 and west of 98th Avenue, was changed to commercial industrial. And the reason that this policy was put in place was to restrict or actually limit the allowable uses of the property. Now, policy 1.36 is different from policy 1.22 in the sense that policy 1.36 is a site-specific policy. It doesn't have general applicability like policy 1.22. Policy 1.22 applies throughout the county and could potentially apply to any land in a commercial industrial node. Policy 1.36 applies to a specific piece of property. So this is a text amendment, and it's an amendment to modify a site-specific policy. And it directly relates to the associated land use map amendment that you're going to be considering next, because that's the property that it's modifying. And it's modifying it to actually, again, limit and restrict the uses that can be put on there. And I'm going to discuss that in a minute. And You'll be seeing this graphic or a variation of it several times tonight, particularly once Hassan goes over the future land use map amendment. But this is the proposed expansion to the State Route 60 I-95 node that you'll be considering in the next comp plan amendment. And this is the property that's outlined in black there that this site-specific policy will apply to. And the changes that are proposed for policy 1.36, first, change the 101.8 acre reference that's in policy 1.36 now to 776 acres, and that will accommodate the additional land that's proposed for redesignation in the amendment you're going to consider in a minute. Also, we're proposing minor modification for the restrictions that are currently in policy 1.36. Most of those are going to apply, well, all those are going to apply to this property like the other property. The only real change we're making is to actually put in the policy that accessory commercial can also be included in here. The basic reason to have the policy is to limit the uses to industrial, warehouse type of uses, not general commercial uses, not RV parks and things like that. It's to have it industrial uses, but there's also a general recognition that commercial accessory uses are appropriate in an industrial park, and this will allow that. The final change to this policy is to limit development on the subject property, the property that's the subject of your next amendment, to a 0.3 floor area ratio. Right now, the county allows a 0.5 floor area ratio for industrial types of uses. This is being more restrictive, and Sasan will explain that. The basic reason to do this is to limit the amount of development on there, so it limits the amount of infrastructure improvements that would be necessary to accommodate that development, and the applicants are in agreement with the 0.3 FAR.
What about the height restriction out there? The height, this is the one node where we have the additional height.
Yes.
Is that going to apply to the whole node? Will that shift over, or?
The height,
not restriction, it's actually
the height allowance, right. The height allowance applies countywide if the criteria is met.
Okay, but it was written in such a way that this node and frankly the CVS building can meet the new heights, but exceeded 50 feet.
Yes.
I don't know that they ended up going over 60, but I thought we had a height limit of 65 feet.
Actually, it was 80 feet, and they went to 68 feet.
Okay, so it was 80. Okay.
If the property here meets the separation distances that we have in there, it would.
Then another big box or whatever could move in and do the same thing.
Yes.
I mean, I don't have a problem with it. I just want to be sure if you're talking large industrial land tracts that they have that right.
Yes. Just a few more things. Really, there are several reasons why the proposed changes to 136 are being proposed. First of all, we needed to implement the proposed additional policy 1.22 exemption, because the policy 1.22 says it's limited to large-scale industrial parks, and 1.36 will ensure that this property will be limited to industrial uses. And it's also needed to ensure that property that's well situated for industrial uses, such as the subject property we're going to be looking at, is limited to industrial and distribution center uses and not retail, commercial, RV parks and other uses like that. So basically, staff feels that policy 1.36 is appropriate to restrict the land uses and enhance economic development for the subject property. There's another policy that we have to look at any time that we're amending the comprehensive plan, and that's policy 14.3. And that policy says that a comp plan amendment can be approved only if one of 4 criteria are met. And in this case, we feel that both proposed policy changes meet the substantial change in circumstances criterion. With respect to policy 1.22, there are several changes in circumstances, but one I said was a change in the county's economic development strategy, that we anticipate creating more demand for industrial sites. and another one is that a portion of the Corrigan Tract, most of the Corrigan Tract west of 95 is being designated as a mitigation bank, and this will keep...
This is not like a land swap, even though we're actually we're trying to capture more commercial in order to avoid it all being mitigation process.
Yeah, that's exactly what we're doing. It isn't the swap, though, but that's one of the justifications here. And finally, 1.36 meets the substantial change in circumstances because it's a site-specific policy, and it's associated with that land use map amendment, and that map amendment is a change in circumstances. So staff recommends, the Planning and Zoning Commission recommend that the Board of County Commissioners approve the proposed changes to policy 1.22 and 1.36 and agree to transmit the proposed amendment to DCA for its review.
I have a question of staff. Should we be, in our process tonight, should we be looking at 1.22 first and then going to item 4B and then coming back to 1.36?
Actually, that's a good point. It's a timing point, but no, you can't take any final action tonight, so I think it's appropriate to look at the text amendment and then the map amendment. But you're right, timing-wise, it would seem reasonable to do 1.22, then do the land use map amendment, and then do 1.36. Here, the recommendations are going to go to the Board of County Commissioners together, so the timing doesn't matter. But that's an excellent point.
Yep.
I have a question. Would this site be limited to large-scale industrial users, or could it be a bunch of small, scattered, smaller users, much like got us into the 70% conundrum in the first place?
It can be smaller scale industrial users, but it will be restricted. It can't be contractors' trades or those types of uses that are more appropriate in the other nodes.
I mean, we all kind of have in our mind a big player is going to come in, but there's no. That's the concept, correct?
No, the concept is it could be a number of smaller users, like a lot of users we have in the county now, like the Machos, the all the others like that. Those would be appropriate. What we really don't want are the quasi-commercial types of uses.
Is there a limitation on lot size, or could they be half acre, 5 acre? I mean, is there any limitations on lot sizes?
There's no limitation, but one of the minor changes that we're making to policy 1.22 is that development on this site needs to be approved as a PD. So you will get the opportunity to specify exactly what uses will be in there with the constraints of policy 1.22.
The development of the entire site as a PD, or each individual applicant that comes in?
Oh, the entire site. What is, and we're sure this is a big piece of property, and it can accommodate a lot of square footage, a lot of floor area. So I'm anticipating it's going to come in several phases. So each phase would be a PD, and actually, PD is the way the industrial park, the Indian River Park Commons was approved. And it really makes a lot of sense, and I think it provides a lot more control for the industrial park developer, too.
Other questions?
I'm not interested in putting additional restrictions on these guys. We need all the space we can get, but I would just, and it's an appropriate location for it, and it's a good idea all the way around from economic development and everything else. But the smaller users can go into the less than 70% that's still available. So I mean,
well, not in a lot of places.
Not in a lot of places.
Because again, we're differentiating. If you look at the users like Macho, Profol, Nylacarb, they can't go in the commercial parts.
I understand.
Yeah,
it's the C and the I.
Yeah,
that's the problem.
Great.
Okay.
Bob, in this, what you're calling an industrial park, it's part of our zoning, there are many other types of companies that could come in. We could get research companies, we could get biotech companies, things like that.
Yes.
I don't know, Council, if it's appropriate at this time this might be a commissioner matter, but I want to discuss it now, and that's the name associated with industrial parks.
Is this the soapbox?
Yeah, it's kind of a soapbox. It's kind of nitpicking too, George. But we are calling these industrial parks, commercial industrial parks. And that connotation to me is a bunch of smokestacks. And nothing wrong with concrete plants, but it brings that to my mind also. And I just think that's archaic, because I hope what we're looking for in part is to become a part of the Treasure Coast's initiative to the life sciences and to research. And I think that name should be reflected in this zoning type, because when we go out, hopefully when our Chamber of Commerce goes out and aggressively seeks those types of companies to try to get them here, and I know times are tough, but that, I believe, is the time to try to go after these companies and get them to come to Indian River County. They're doing it south of us, and we need to be a part of that too, because that's definitely the future. We've got a local college here that has the initiative of training in many of those diverse areas that are associated with a global economy. And I would really like to see this name change to reflect what we're trying to do. Now, I'm very much for this, what you're doing tonight with the Corrigan property. But I'd just like to see a different name come about so that we can go out there and say something different than a smokestack industrial park.
What do you
I'd like to
suggest?
know what the commission.
Why don't we tell Penny to put on her hat out there and tell the chamber to come up with something?
Please got something up her sleeve.
But- And as you know, the property to the east has the name of the Indian River Park of Commerce, so they don't have industrial in the name, and
I know, but I don't understand exactly what that means either, Bob.
Sasan Rohani, Chief Long Range Planning. Actually, in the economic development element, we are using business/research life science park. Isn't that true? We changed it, to make it similar to what we are looking for. And that is like throughout our economic development element, now that is the term that we are using.
So we're going to change the designation. It's not going to be called an industrial park anymore.
Again, in this case, is a commercial industrial land use designation with industrial use, but actually, as far as industrial park, we are not calling them industrial park anymore. We're calling it research/business park/life science.
I did have an idea.
Okay.
For the record, Hilary Castletine, Economic Development Director with the Indian River County Chamber of Commerce. Just a flash in my mind was the Indian River Research and Business Park. Simple enough. Easy to say.
Better than an industrial park, that's for
Yes.
sure.
Yes, and that encompasses just about anything that we might want to put in there.
Can we pass this first and then name it later?
If we're going to be changing the names, that's a text change, are we going to need to incorporate that into policy 1.22? Because we're not going to be calling it a large-scale industrial park. It's going to be called a large-scale something else.
yeah, we can work on that.
Okay.
Large-scale research, life science research park, or something to that effect.
Yes.
All right. And now, Bob, we need to make the recommendation? Or accept the recommendation to the...
Open the public hearing.
You got to open the public.
Oh, that's right, I'm sorry.
All those sworn people out there.
Yeah. We got kids from schools, and is there anyone from the public that would like to speak? You don't have to be sworn in for this.
Just remember the Barquette rule, Chris.
Somebody want to swear me in? I'm supposed to do that with lawyers.
Aren't you an officer of the law?
Is it okay?
You okay?
It's legislative, so you don't have to be sworn in.
Okay, thank you. I'm Christopher Marine. I represent most of the applicants. I represent the Corrigans, and I represent the Lambeths, and I represent Mr. Beatty. Mr. Bailey, the fourth applicant, is represented by Bruce Barquette. who's not here anymore. I'm sure he was just very confident in, my delivery, and he just felt like it would be fine without him being present. I have prepared statements, but I kind of see the direction that things are going, so I would just be happy to entertain questions. I would say this, however, this application that's before you tonight is just part of a process that the Corrigans are going through right now. We've been working on it for about a year and a half. And that is the future long-term land use for the ranch. They've been focusing on that in a way that they really never have in the past. The Corrigans bought the property in the late 40s, and they've basically had a ranching operation on it and some farming, but predominantly ranching, and it continues to be an operating ranch now for over 60 years. What we're planning to do is a mitigation bank, a wetlands mitigation bank. Not many people know a whole lot about mitigation banks, but it's a very exciting project, and what's going to be involved with this is the ranch, which is west of the interstate, which is about 5,500 acres. Over 5,000 of that will be placed in conservation, and that's a voluntary conservation easement. No one's buying it. They'll do that, and it'll be permanent conservation. And then what they will do is that will ensure it won't be developed. The west side will never be developed. It will become its own ecosystem for wildlife purposes, a green corridor, if you will. But that's permanent. That's a permanent commitment. And then what the Corrigans plan to do is to restore all the wetlands and to restore this land to what it was historically, to the conditions, hopefully, will end up to be just as they were before all the drainage was organized years and years ago. So we're involved in that project right now. We filed a mitigation bank. Is a very complicated regulatory animal. You have to start with the Army Corps of Engineers, which we did about a year ago. We've got a preliminary nod from them back in November. So in December, we filed with the St. Johns River Water Management District, and they're looking at it now. So we're going through the channels in hopes that we can have a mitigation bank in place as quickly as possible that will be utilized to offset wetlands impacts of development within our community, within our basin, for many years to come, hopefully many decades to come. So it's an exciting project. This part of it, this portion of the balance of the ranch, is approximately 7%. About 93% of the ranch is going to go into a conservation easement. This portion of it is really what makes the other portion financially feasible, at least in the early years. So even though we're not going to be before you, if any, on the mitigation bank, I wanted you to be aware of it because they're moving in tandem. Both applications, both projects are moving in tandem with one another. I can answer any questions that you may have.
Thank you, Chris, and I'm sure there will be some questions, but it just shows that the Corrigans continue to be great caretakers of the land in Indian River County. I, for one, certainly appreciate that.
Thank you.
A question with the mitigation bank, and I'm looking at this in a positive way. They are going to still be able to use that land as a continuing cattle operation, aren't they?
Well, ultimately, the cattle operation will have to be retired.
And right away, or over?
No, not right away. That's part of the process of establishing a mitigation bank. You have to come up with a management plan with the state agency that is based upon best management practices. What that means to the Corrigans right now is that, and they'll kind of hammer out those issues and those details over the course of the process. What that means to them, however, is for the portion of the ranch that's put in conservation right away, which is about half the ranch in the first phase, they'll have to significantly limit the amount of cattle that can be placed on there because, Jens, you probably know more about it than I do. It's not like a normal cattle operation. It's going to be compressed significantly. Right. For the balance of the ranch that's not put, immediately in conservation, they'll continue that operation. Ultimately, there'll be no cattle operation there, or only a very limited one. Right. Okay. So it'll be a milestone, but it's something that they've embraced and they're really excited about.
Yeah, I was just hoping that the cattle end of it wasn't going to be phased out immediately.
That's not the plan.
Good.
Yes, sir.
What an amazing gift.
Yeah.
Thank you. Amazing.
You're welcome. We're very excited about it.
I can see why.
Me too.
Thank you. And with that,
We closed with the public hearing closed. Would you like a motion?
closed public hearing. I'm not with it tonight.
Accept, staff's recommendations on both 1.22 and 1.36, and with the added caveat of an added creativity of a name if possible.
Second.
Motion and second. All those in favor, say aye.
Aye.
Opposed? Thank you. Thank you, George.
You're welcome. Unbundle that one. I'm going to take it.
Now we got commission matters.
Thank you.
Stan, you have,
We have the second
You got the
public
other
hearing,
half of
B,
this.
the map amendment.
somebody send me out and tell me to come back.
Hello, Sasan Rohani, Chief Long Planning. Actually, both Bob and Chris, they made my presentation much easier because they already talked about most of the things that I was going to.
You got to move the burden service area. Encompassing the lane.
Okay, the land use part of the comprehensive plan amendment is for 674 acre. And to do that, we need to expand the urban service area and also redesignate the land from AG2, which is agriculture, to up to 1 unit per 10 acre to commercial industrial. The property is 5 different property, and they have a different owners, and here are the list of the owners of the property. And again, the purpose is to create a large scale business, life science, technology park.
Thank you, Stan.
Very good.
Again, at least, again, like that they mentioned here, again, Corrigan has a large property here, is a 5,300 acre, and over 5,000 acre of it is for the medication bank, and the rest of them here with some other property we are considering for the land use amendment for commercial industrial. Basically, this is the location of the property, which is just to the west of CVS distribution center, west of 102nd Ave, and north of State Road 60. The property and most of the surrounding property currently have a land use designation of AG2, which is agricultural land use designation, and to the southeast of the property, the land use designation is commercial industrial. If eventually approved, this is going to be how it's going to look like, and it's going to be commercial industrial designated property. As you're familiar, usually we review all of these criteria when we analyze a request for a land use amendment or a rezoning. As far as the concurrency, again, as you know, these are the criteria like transportation, water, sewer, solid waste, and so forth that we look for concurrency. A property in 674 acre, even with the floor area ratio of 0.3, it would accommodate more than 9 million square feet of industrial. And if you put all of those things in place right now, of course, going to affect some of the facilities, like some of the roadways and so forth, going to be deficient. However, we know for a fact that the property that large is not going to be developed at once. It's going to be gradually through the time, and for each step of the project, they need to come and apply for initial concurrency. At the time of the initial concurrency, we make sure that there is sufficient capacity that they could proceed. At this point, since they are only doing the land use amendment, and this is not a project, just a land use amendment, we look at the conditional concurrency. For conditional concurrency, we have to make sure that when there is a deficient link like that, we identify some of them here, there is a feasibility of these things being built. Like, for example, State Road, I-95 and 66th Avenue already planned project. Those are going to be done through the appropriate means that already there is a plan for them. For State Road 60 and also for 4th Street between 74th Ave and 98th Ave, most likely applicant going to do those things. Like for a project of this magnitude, like the applicant actually has to pay more than $22 million of the impact fees. Therefore, they could able to actually go and build those units and then get the impact fee credit. Basically, like to make it, like in a summary, yes, right now, if that project would come today and they want to build, there would be some deficiency, but since it's going to build gradually, and since between the planned project and between what the applicant is going to do, there is going to be sufficient capacity, therefore they meet the conditional concurrency test, and we could proceed with the land use amendment. As far as the compatibility, this is really appropriate site for these type of the big, large-scale technology, business, life science park, because again, as you know, surrounded by agriculture, and also, again, this is actually, the area of the thing, as you can see, there is an agriculture area all surrounding the property, and at the southeast, there is already industrial designated land, which is a continuation of that one. Therefore, we don't anticipate any problem with the compatibility of this site with the surrounding area. As far as the environmental impact, in the area being considered for the redesignation, there is 75 acres of the native upland. As you know, we have regulation that they have to set aside 15% of that one. Also, there are about 50 acres of the forested or emerged wetland. Basically, the regulation said that they need to minimize the impact or mitigate for it. Also, most of the property is a 100-year floodplain. However, all of these issues, they are the issues that they were going to consider at the time of the development. They're going to make sure that if there is any wetland impact going to mitigate it, they're going to raise the flood base level and so forth to make sure that they meet all the requirements. As far as the consistency with the comprehensive plan, like Bob mentioned, we always have to look at the policy 14.3, and they have to meet at least one of these 4 criteria. In this case, they meet the substantial change in circumstances. Bob explained this one in detail, and I don't want to spend more time in it, but again, as the site is really the most appropriate size for this type of the development, and also because of the change of circumstance that Bob mentioned, like all of the economic development initiative, economic development element of the comprehensive plan, that now they are actually want us to have 2 more industrial park, and also basically for this type of the big, large-scale development for industrial type, we had 3 choices. One is Oslo Road and I-95, that we don't have an interchange there. The other one was County Road 512 on I-95. Most of that land was annexed by the city of Ellesmere. Therefore, really the only choice is State Road 60 and I-95, and this is really the most appropriate place for it.
Susan, excuse me, but didn't Ellesmere, did all that acreage is residential, none of that's industrial? At 512 and 95?
Actually, you've got 4 quadrants up there. The Fellsmere 392 property that they annexed in the northeast, they changed to residential and regional commercial, not industrial. In the southeast quadrant, the property's in the unincorporated county and it's an RV park. In the Northwest, it's almost all conservation, and what isn't conservation is commercial there. The only part of that interchange that can be used for industrial is the Anson 3700, which is on the southwest, and they've been going through the agencies trying to deal with the wetland issues for the last 10 years.
Can we have an industrial park out, since we've talked about this, outside of the urban service area?
We're moving the urban service
I
line.
understand. So we have no, if we approve the first ones, but this is a no-brainer, right? I mean, we can't have the industrial park or allow the industrial land without moving the urban service area.
Correct.
Exactly. Also, these amendments meet policy 1.22 for the same reason that we mentioned for the other policies, also meet all of the economic development objectives and policies, and is consistent with the comprehensive plan. Therefore, staff recommend that the Planning and Zoning Commission recommend that the Board of the County Commissioner expand the urban service area and redesignate this property to industrial commercial, and we submit these to the Department of Community Affairs for their reviews. Thank you.
Questions? Hearing none.
So we're being asked to move the urban service area, is what it really boils down to.
Yes.
And right now, the CVX property is included in the urban service area because they had to have water and sewer, the utility.
Yes.
And so we're just moving it to incorporate this property.
Exactly.
And it'll go to the western. Right. And I mean, that makes sense. But, so the western edge of this property will be, that'll be the demarcation of the new section of the urban service area.
Yes, and there's no residential development that will be within this urban service area expansion, so there'll be actually no increase in actually population yield coming from this.
Basically, this figure here shows the boundary of the urban service area after it is moved.
That's the property to the west.
Yeah, it's all the way. It just goes over to Buckhammock.
Public hearing now. Anyone from the public who wishes to speak? Hearing none. Public hearing is closed. It's your pleasure.
You need a motion? I'd move that we go with staff's recommendation and move the urban service area to encompass this new industrial, whatever economic development park we're talking about.
I'll second that.
Moved and seconded. Any discussion? All those in favor?
Aye.
Aye.
Opposed? Thank you. Commission matters?
Can we put the soapbox back in?
You got my 10
It's
minutes
gone.
if you want it, Greg.
Planning matters?
Just a few items, Mr. Chairman. At the May 11th Board of County Commissioners meeting, the Waterway Village items that you all looked at tonight will be going to the Board of County Commissioners for their action, and your recommendation will be going with them. The other thing that I did just want to mention, just kind of taking a quick look back, I think I wouldn't mind getting just a little bit of feedback from you all. From staff's perspective, the joint workshop Monday was really good, and it was we were pleased with it. I thought getting with that big of an issue, having you all there to talk directly to the board and kind of go through everything worked well. But I appreciate any feedback you all have. Do you think it worked like we thought that it worked?
Actually, George and I were trying to figure out why it works so smoothly.
Well, you all had gone through everything. I mean, I really think that, well, one of the things that happens
Staff
is
didn't want to go through the steamroller again, that's all.
when we go through it with you all, it helps us
Yeah.
narrow down the issues as well that need that the people want to discuss, and really, it helps us highlight things.
You
And
were
I
way
think
too
that-
accommodating.
What I thought is that because of what you had done, you all were very focused on what was put in the EARs. I mean, it's been boilerplated. What happened today at 2:00 or at the Ag meeting?
Yeah.
Actually, I was at the Ag Advisory Committee, or most of the meeting. I was.
I can talk about it with you afterwards if you all. That's okay. Yeah.
It was
like to know.
mostly informational presentations.
Okay.
What was this about, water farming or what?
Well, they had to deal with the ag part of the land development use regulation, I think. Wasn't it? What was it? That wasn't what it was? I thought you were presenting that to them when you'd gone over.
No,
Oh,
it was basically updates on canker, greening, black spot, things like that, and some other ag issues.
Glad I missed it.
That's it, Sam?
That's all I had.
All right. Attorney matters?
Nothing tonight, Mr. Chairman.
Okay. We are adjourned.
George, I think what happened at the workshop the other day was you confused them so much with Donna Cox that they just couldn't handle dealing with the rest of it.